Okay, are we ready to go?
Ready.
Okay, good morning, everyone. We will now call to order the
Rivera.
And good morning, Your Honor. Marshall Webster on behalf of the appellant, Jose Rivera. Mr. Attorney Richard De La Fera will be arguing this appeal this morning, Your Honor, on behalf of the appellant.
Good morning. Good morning, Justices. This is Michael Francisco on behalf of the Attorney General's Office representing Appellee, people of the Virgin Islands.
Okay, so you're not Clement. Okay, so we make sure we we will proceed. As you know, you have 15 minutes each. How much would you like to reserve for?
Yes, Chief Justice, 4 minutes for rebuttal, Your Honor.
Very well. Okay, then we will call the case Rivera versus the People, number 40 of 2020. You may proceed.
May it please the court, my name is Richard De La Fera. I represent the appellant Jose Rivera. Again, I'd like to reserve 4 minutes for rebuttal.
Very well.
Mr. Rivera appeals the lower court's denial of his motion for new trial based on newly discovered evidence. Mr. Rivera acknowledges that under the law of this court, motions for new trial should be granted sparingly and only in exceptional circumstances. However, we submit that this case involves exceptional circumstances which warrant a new trial. The court, I believe, is familiar with the material facts of the case. The court reviewed this matter on direct appeal. And namely, there was only one witness brought by the People who testified that Mr. Rivera committed the murder of Officer Wendell Williams on June 14th, 2001. Ms. Kugel, Teresa Kugel, the witness, gave a first statement to law enforcement that Mr. Rivera committed the murder a year after the incident. Mr. Rivera was not indicted for the crime until 11 years after the alleged incident. And during the pretrial discovery period, the People successfully withheld the identity of Ms. Kugel as the eyewitness. Ms. Kugel was not disclosed to the defense until December 27, 2013, with jury selection set January 21st, 2014. And as Mr. Rivera indicated in his motion for new trial and also at the hearing before Judge Donahue on the motion for new trial, explained how the late disclosure hampered his ability to conduct investigation that he otherwise would have conducted. This court has set forth 5 factors in determining whether a motion for new trial should be granted in Phillips versus People and a number of other decisions from this court. And namely, the evidence must be discovered since trial. The facts must be alleged that infer due diligence on the part of the movement. The evidence must not be merely cumulative or impeachment. The evidence must be material. And finally, the evidence must be such and of such a nature that it would probably produce an acquittal on a new trial. And
how is any of this evidence newly discovered?
Well, Judge, as Rivera put forth in his motion and at the hearing, he was delayed in finding this information because of the late disclosure of the witness. So it was impossible for him to fully investigate and put together the information that he was able to do after trial. So if we look at the affidavits of Francisco Velasquez and Kenny Melendez, as is put forth in the motion and stated at the hearing, they were able to locate them and get their testimony through an investigator.
But didn't defense counsel basically, with respect to Francisco Velasquez, didn't he indicate he was going to call him, but that he had a work conflict? So how is his testimony newly discovered? And for Kenny Melendez, wasn't Kugel questioned and cross-examined about him, where she denied that he was her boyfriend, that they only went out for dinner? So how is any of this newly discovered? You had access to these witnesses before trial.
Well, I think as laid out in the motion, while these names may have been made aware of to counsel at the time of trial, presumably through the family members that were called, the testimony was unable to be secured because of the late disclosure. So I would submit that the existence of these people might have been known, but the actual testimony and the ability to bring these people to trial was not available to counsel again. And I think it's very important to emphasize, and I think this goes to the due diligence prong of the Phillips factors.
Attorney, I have a question. The day that the jury was picked, and what was the time lapse between the day the jury was picked and when the actual trial started with the first witness? Did they had some days that elapsed between them?
Yes, they did, Justice.
Right, about 7 days, am I correct?
That's correct.
Okay, and I'm assuming that she was disclosed or divulged to the defendant, that is Ms. Kugel, on the day of jury selection, am I correct?
Well, Judge, I would say even according to the docket, the Kugel was disclosed on December 27th.
27th?
Yes.
All right.
27th.
So how many days between when she was disclosed and when the trial actually started, that what's the lapse of time in that? Because
no, and I understand, Justice. It's 30. I count 32 days. But
32 days. Right. Okay. Hold on. 32 days. Is there any question as to where the defendants are contending that she was located in Florida, staying with one of the original defendants' sister, living in her apartment with the sister's son? Is there any reason why they could not have located her or get information on her?
On Ms. Kugel?
Absolutely.
Yes. Well, one of the things that was pointed out in the motion that I think is it bears repeating here is that the time frame that Kugel was disclosed was over the holiday period between Christmas Day and Three Kings Day. And as counsel for Rivera stated in the motion and at the hearing, the holiday interfered with his ability to conduct the thorough investigation that he had hoped to do and that he eventually did.
All right. Well, let me ask you this. Once the jury was selected, but not sworn in, and before trial started, you know where Kugel was going to be the main witness. What we would euphemistically say, the straw that stirs the drink. Did anybody ask the court for an extension of time for another week for trial? Was there a motion for a continuance for a brief hiatus period?
No.
I don't see any.
And I don't either, Justice.
Well, okay, but wouldn't it have been prudent, knowing that she was disclosed, according to you, 30-something days before, you know that the jury is picked. You don't have to worry unless the jurors are sworn. Do you still have time, holidays or no holidays, to really find out what you wanted to discover about this main witness? Because everybody knows by then who was going to be the main witness in all of this. You had the statements. She had like 7 to 11 interviews, with FBI people, with local police, and with everybody. And all these things, have I read the record that these things were disclosed to the defense?
Right. The statements were disclosed to the defense, but the identity of the person making the statements was not disclosed until
Right.
December.
Right. Okay. But you still have 30-something days, because once you find out who it was, is there any question that Maximilian Velasquez and all of the other defendants couldn't find out or didn't know that she was staying with one of the defendant's sisters was it in Tampa, Florida, or in Miami, Florida?
Well, once the identity was disclosed, then the investigation could begin as to looking out for what they could find to prove that she was not in St. Croix on June.
Absolutely. And the people that would prove that, according to the defense, that she was not in St. Croix was one of the defendant's sisters with whom she was living.
Right. And I think upon
and the nephew with whom she was living. And Maximilian knew also where she was.
Well, but I think it's important to note that you don't know who the person is making the statement that she was that they were an eyewitness, because I don't even believe the gender was disclosed until December 27th. So really, the investigation of Teresa Kugel cannot begin until December 27th.
But is there any question that, in terms of finding her? Was she in Timbuktu? Was she in Europe? Was she in Australia? She was right up there in Florida.
Well, I'm sorry, Justice.
Yeah, and everybody knew where she was located. Is there any question as to?
Well, I don't know that on December 27th, 2013.
Or at least 2 weeks before trial.
Right, that anybody knew where she was located. I would presume that she was in some kind of witness safety custody. I think there was talk in the record about her staying in Puerto Rico during the trial. So I don't think, while her identity may have been disclosed to the defense, I don't believe that her location was disclosed to the defense. Justice,
when you got the statements, and based on the reading of those statements, wouldn't it have been clear to counsel who that witness was, even though the name wasn't disclosed?
I don't know that it is apparent, and certainly not to Mr. Rivera. If Mr. Maximiliano Velasquez is the boyfriend or the father of the child, I can't really speak to that. But I would say, as far as Mr. Rivera, I don't think Mr. Rivera had any association with Miss Kugel that would have led him to discern that was the person that was making the statements.
Let me ask you, with respect to, before your time run out, with respect to her presence in the Virgin Islands. Her presence in the Virgin Islands.
Yes. Oh, I think we have a.
Yeah, I'm hearing an echo, so
yeah.
Hope IT can get that resolved. But the fact that all of the evidence that you've presented, the Wendy's pay stubs, they started after, is the fact that you haven't presented anything that showed that she was actually in Miami in the middle of the month, kind of proved the case that she was not there, or she doesn't that really hurt you, that everything that you've presented started after or before? The baby was born after, the pay stub started after. You can't get any of the records, the customs I-94 forms that everyone filled out at the time. None of those could be produced. Doesn't that kind of disprove your case?
Well, I would submit that the Wendy's records and the hospital records, they buffet the time of the alleged incident. But I think the most important piece of newly discovered evidence that I would ask this court to look at, and I think it's very, very crucial, is Exhibit 8, which is the email from the prosecutor to Attorney Ray that says that the FBI agent made an inquiry at the time that could not find any record of travel. And while I understand that Judge Donahue took the position that the absence of a record didn't prove anything, I submit that that was an erroneous finding of fact. Because
they couldn't find that she traveled in March, which everyone knew that she left the Virgin Islands and traveled in March, and there was no record then either.
Well, I don't know, and I know that Judge Donahue focused on that as well, and I don't read the email as broadly as most respectfully the Superior Court judge did. But I think what's important is that this was evidence that either is newly discovered evidence or it's Brady. And I know that Judge Donahue disputed that it was Brady. He didn't find that it was favorable, but I suggest, and I think under the catch-all prong under Rule 135, that if this jury was presented with evidence, with the fact that there was no evidence that she had traveled, had left St. Croix to go to Miami after the June 14th date, that would certainly raise a doubt as to whether she was in St. Croix back on June 14th, because we know.
Hold on, attorney. Hold on just 1 second, attorney. Hold on just 1 second. The main witness, Kugel's sister, am I correct? She testified at the trial?
Yes, this Sandra Rivera.
Okay. And she said unequivocally that her sister was not on St. Croix. She said that because our mother made birthday, she wasn't there. And she said, I used to take my son. My mother was babysitting my son. And at least 5 days a week, I would go by the house. But in her testimony in the appendix, when asked a straightforward question, she said, no, her sister, the main witness, Kugel, was not on St. Croix. Well, that's what she said.
Well, that was the.
So to say that that the defendant did not get in contradictory testimony by somebody that would know and would supposedly would have knowledge as to the whereabouts of Kugel, the sister, who was supposedly living with the mother.
Well, Justice Swan, if I could just point out, yes, the direct testimony is exactly as Your Honor has stated. However, the prosecutor very cleverly asked basically one question of Ms. Rivera, the sister, on cross-examination. Can you say positively, definitively, during this time frame you talked about in mid-2001, that Teresa Kugel had never gotten on an airplane and come back to St. Croix for a visit? And the answer was no. So now we have a dispute so Ms. Rivera was proven by the prosecutor to not be 100% certain because I think Justice Donahue said nobody is with anybody 24 hours a day.
All right.
Okay.
Well, let me ask this, attorney.
Let me just ask Judge Hodge, did I hear you start to ask a question?
Yes, I wanted to ask Attorney Rivera, before his initial time runs out, can he quickly summarize for me why he concludes that this is newly discovered evidence?
Well, certainly, Justice Hodge, certainly the information that the FBI agent had conducted a search for records and had not found them, that's certainly newly discovered. I don't think that's nothing that was ever brought up prior to the trial. So, and that's Exhibit 8 of the motion. The other testimony, as I've said, the affidavits of Melendez, Francisco Velasquez, and Jose Rodriguez, they are after trial. They are new. I submit they are newly discovered because of the inability of counsel to conduct the full investigation. He was able, as he said in the motion hearing, he was able to locate the sister that the woman lived with in Miami and Mariela Velasquez. and the sister here in St. Croix who would visit the mother every day.
Okay,
No, I-
thank you. Thank you.
Okay.
You'll come back with your 4 minutes. We'll now move to the government. We'll hear from the people. Attorney Francisco, you may proceed.
Morning, Justices. If it pleases the court, my name is Michael Francisco. Again, I'm here on behalf of Appalachia, the people of the Virgin Islands. Your Honors, there is
Attorney
one issue.
Francisco, if you would just adjust your screen a little bit so we see the top of your head rather than.
There we go.
Okay, thank you. Okay, good.
Your Honors, there is one issue in this case, and that is whether the Superior Court erred or abused its discretion in concluding that appellant did not clear the high hurdle required to support the grant of a new trial. The people submit it did not, because none of Mr. Rivera's exhibits, as this point astutely noted, satisfy the 5-part test laid out by this court in Phillips. That is not a single piece of evidence, supposedly new evidence, was not either cumulative or immaterial, or was not known of by the defense prior to his original trial. In fact, nothing Mr. Rivera has provided to the court could even reasonably be considered to lead to an acquittal. That is why there was no error or abuse of discretion in this case. The lower court reviewed each piece of evidence under the correct legal standard, made appropriate findings, and properly concluded Mr. Rivera did not carry his heavy burden. And bear in mind, this was from the same judge who actually heard evidence at the original trial. Now, Your Honors, motions for a new trial, like appellants, require a strong showing to justify the drastic step of overturning a jury's verdict. They're not granted simply on appellant's claims. They must be deemed necessary in the interest of justice. But there is no manifest injustice here. Mr. Rivera is guilty, and this court has already ruled that the evidence presented at trial was sufficient to support that guilty verdict. Now, since Mr. Rivera has failed to establish any clear error or abuse of discretion on behalf of the Superior Court, this court should uphold the denial of appellant's motion for new trial. With that, the people stand ready to answer any questions the court may have.
Yeah, well, Attorney, am I correct that all of this thing about a newly discovered evidence is nothing more than impeaching evidence?
In many instances,
It's more impeaching evidence than newly discovered evidence. Am I correct?
well, the fact that it is not either cumulative or impeaching is one of the 5 parts to the Phillips test.
All right. Am I correct that this whole case as to the whereabouts of Ms. Kugel on June 11th is really a matter of credibility? Her credibility on the one hand against all of the defendant's witnesses on the other. And the jurors made a conscientious decision, deliberate decision on credibility. Am I correct that this is all about credibility? It's who you believe.
Well, yes, it is. However, each it's a very tough test to pass. And as you pointed out, that simply weren't newly discovered. They were known of at the time of trial. Francisco Velasquez in particular was mentioned not once, but twice. Once by Mariella, and then again by the defendant or the defense at closing. And I could give citations for that, but the point is, not every piece of evidence meets the first test of having been discovered only after trial. Now,
All
various
right,
other pieces.
But let me ask you this, Attorney. The whole thing centers around where was Ms. Kugel on June 11th? Was she in Miami or possibly in Tampa, or was she on the island of St. Croix, Santa Cruz? And 2, whether or not how relate of that story, is there any concrete evidence of that vis-a-vis the abandoned building, the pole in the center of the building, the generator that was there, the outlets that were there that she contended that that the victim was being electrocuted, to the extent of the big issues in the case as to her credibility. Doesn't it seem as if that her credibility as to this dastardly deed was corroborated when Ortiz and others went out there at Grade 3?
Yes, Justice, I would agree. And in fact, a lot has been made that there's a single evidence or a single witness in this case. But in fact, the prosecution brought up several.
Well, it really doesn't matter whether it's a single witness or not. It's whether or not two things. One, do the jurors believe that single witness? And two, does what the single witness says, is that corroboration of physical evidence and by other people? And particularly, nobody yet have mentioned the Cousinberry and Goodman's interview of Hector. And I think that that was the icing on the cake. When he says that he saw this same victim with his hand tied, and when Miss Kugel got there, his hand was in fact still tied around the pole. So, you know, if you believe what the two FBI agents said that this gentleman told them as to why the victim became a victim, and when you go to the so-called crime scene, and if you find things at the crime scene that substantiate what Google says, then you weigh all of that against all the other impeachment inconsistencies, whether she takes ecstasy, marijuana, or or cocaine, which she said that at the time she was not either of them. But if you weigh all of that, doesn't it boil down to simply credibility and whether there is substantiation of her credibility?
Yes, Your Honor, you are correct. And the jury made that determination at trial. They weighed all of the evidence, defense witnesses. They heard at least 3 defense counsels provide closing arguments to the effect that there was a lack of travel records. They did forward the idea of a VIPD conspiracy theory. They discussed, or rather attacked Teresa Kugel's motives, saying she had done.
I mean, the defense give a blistering cross-examination of this young lady. and it was a very good cross-examination, and despite all that, despite the inconsistencies in the 7 or 8 reports that she gave, and despite the fact that, well, sometimes people got to be very careful when people are interviewing people, because if they didn't ask her about the poll, she wouldn't necessarily volunteer that. And they make much to do that. They took an hour and a half to find the alleged crime scene. Well, this is 10 years later, and the brush have grown up. So, I mean, it seems as if that there are some of our inconsistencies. There's a basis for it.
Correct, Your Honor, and the prosecution did a good job of pointing that out. That especially over the course of 11 years, the core central theme to her testimony remained the same over that period. The jury
there was testimony that at least she said she could see the ocean from this cottage, from this villa, whatever it was, and the evidence was clear that you could not see the ocean from that location. But beyond that, I just want to ask, since Justice Swan asked about it, the testimony of the Davis brothers, especially Hector, I think it is, that he saw this person with his hands tied behind his back in the vehicle with a police file and a gun. And the fact that that came out in evidence, and that the prosecutor, although I assumed that it was a limiting instruction that could only be used for credibility purpose, it couldn't be used as direct evidence. Because the witness testified on the stand that he did not say that. And then they used his prior statements, which at the time could only be used to attack his credibility. It could not, I guess at the time, the way the law was, it probably could be used as a case in chief, but counsel argued in his closing arguments that that testimony corroborated Kugel's testimony. And therefore, how is that proper evidence before the court, where you have not only using the prior statements where this person says that Rivera told him that he had to kill the cop, he didn't know he was a cop. How did that get into the case in chief that the prosecutor can argue that it corroborated Kugel's testimony? And can you call a witness just to discredit the witness?
Well, Your Honor, I will certainly answer the question, although I don't think that as it pertains to these 10 pieces of quote unquote newly discovered evidence provided, that
this is a direct appeal, correct? We allowed him to appeal, so it's a direct appeal, and if the court were to find something that could be a clear error, the court could recognize it, correct?
Correct, sir. However, I would point the court to its own decision in Ventura v. People, his direct appeal, in which the court did cover that issue specifically. And the court ruled that despite the fact that the testimony given by the FBI agents to refute via prior inconsistent statement, the testimonies of Hector and Jimmy Davis, there was a limiting instruction. And the prosecution, if you go back and read that testimony, it was the prosecution asking the Davis brothers, did you say X, Y, and Z? That actually their denial of what the prosecutor was bringing out was, provided essentially the testimony that the Davis brothers recanted on the stand, rather the statements they recanted. I don't think it was actually the FBI agents.
But then the FBI agents themselves took the stand and testified as to those statements. And that's what I'm concerned about.
Correct. And Your Honor, to be forthcoming, this court did rule in Ventura v. People that may have been improper to allow the FBI agents to go into a little bit further the reasons, or rather what the Davis brothers had told them, as opposed to just providing straight down the line impeachment testimony. It shaded into substantive testimony. However, that is why the limiting instruction was given. And that is also why this court in Ventura's direct appeal decided that issue was not sufficient to overturn the verdict in the first instance. Now, this court did give both defendants an opportunity to provide, or rather to argue for a motion for new trial, and neither were successful, despite the fact that both had completely different arguments. If you go back and read Rivera's motion for new trial, the original, as well as the one that was provided after the fact, they don't have any of these pieces of evidence in their motion for new trial. This motion was filed in January of 2017 after it was on remand. So they were granted another opportunity to provide all of this evidence to the Superior Court. The Superior Court applied the proper test from Phillips. And their problem really is this is a very difficult standard to meet. It requires that the Superior Court recognize or acknowledge that there's a manifest injustice and a serious danger that there's an innocent person behind bars. But I would submit that if this court were to go back and read the trial testimony, which the people have, this is not based on the single testimony of one witness. There were a lot of different corroborating to Judge Swan's, to use Justice Swan's words, corroborating physical evidence of what was there at the scene. They had Detective Frankie Ortiz, several FBI agents. This was a long investigation that led to the correct result. Jose Rivera and his co-defendant, Ventura, were found guilty by a jury of their peers. 3 of their co-defendants were let go acquitted because the evidence was not sufficient. But as it pertained to these 2 defendants, the evidence in the jury's mind was more than sufficient. And then this court has said on direct appeal, when it affirmed those verdicts, that the evidence was in fact sufficient. So I believe that's a very valid point to make. However, the 10 pieces of evidence, as you pointed out in appellant's argument, provide nothing concrete for this court to make that leap of faith to say that an innocent person is behind bars. All right. Francisco Velasquez, Jose Rodriguez's affidavit is incredible in and of itself. He forwards a theory of VIPD corruption, which again, the defense covered in its closing. but he forwards this outrageous VIPD corruption story that is countered by the fact that the Davis brothers go on the stand and say it's actually the FBI who is responsible for this conspiracy. So you'd have to believe that the FBI was in cahoots with the VIPD. And you know, the entire theory just falls apart, not to mention the fact that if you read his affidavit, there's no dates. There's nothing concrete in there except allegations from a convicted felon.
Let me just ask you one last thing since your time is out. You would agree that if much stronger testimony on an issue that had been covered at trial but wasn't available, you would agree that that is not merely cumulative if it is much stronger than what was presented to the jury. In other words, the only way you ever get a new trial years after a conviction is because somebody come up with some more concrete evidence that can refute an issue that was presented at trial. So you can say, well, there was a trial, the jury had it and could consider it, but if it was much stronger, you would agree, would you not, that you can't just simply consider it as cumulative?
I would agree that there are 5 parts to this test, only one of which covers that it's cumulative. And they have a very strict, very difficult standard to meet. Not every piece of evidence was cumulative, although I think the Superior Court was correct in determining that certain pieces were merely cumulative. They wouldn't have added anything.
But whatever new evidence, real strong evidence that would contradict what Kugel said, you can say, well, that's impeachment testimony. But if it really impeaches it, you just can't dismiss it as mere impeachment testimony, can you?
Well, I would suggest that the defense actually did a fantastic job at trial refuting what Teresa Kugel was testifying
I understand,
to.
but if you come up with something after the fact, which is the only way that people are freed after, whether it's by an innocence project or whatever, is that you come up with some evidence that will contradict what was said at trial. So it seems to me that the government is basically arguing here that because an issue was addressed at trial, anything new is merely cumulative or goes to impeachment. And I just want to be sure that there can be instances where you can discover new evidence that touches on things presented that should be considered by the court.
Of course, Your Honor, that is correct. Although I would point out, you yourself mentioned in appellant's argument that there is nothing concrete on which to base these claims. None of the pieces of evidence, when taken individually or collectively, provide the court with enough to say that this defendant, not potential future defendants, but this one, Mr. Rivera, deserves a new trial.
Okay,
And
thank you.
I'll leave it at that.
We'll now hear from Attorney De La Ferrer. If you would, I think you got 4 minutes. So
Thank you. I wish I had more, but
yeah, but you can take your hand down now since you.
okay. Well, let me start where Chief Justice, where you left off. You know, the factor says merely cumulative, or merely impeaching, and I think if you were to look at the prosecutor's cross-examination of Mariela Velasquez, he only assailed her very briefly for being Maximiliano's brother and Jose Ventura's brother, to suggest to the jury that she is making up this story because of her brothers. Kenny Melendez, who provided the affidavit, is not a family member. So that argument of the prosecutor doesn't have the same weight when you're looking at Melendez saying that he was with Kugel, very regularly during the time frame. As far as Rivera is concerned, the testimony that she couldn't say for certain that Kugel was not on St. Croix, that's where the travel records, I think, become important. So we have evidence, newly discovered evidence, that goes to issues. The main issue in the case was Kugel in a position to observe what she says she observed. And I think a full reading of the trial suggests there is no physical evidence that corroborates Miss Kugel. There is no corroborative evidence that was presented with regard to that. In fact, as Chief Justice pointed out, some of her descriptions were actually disproven. So if at a new trial with this new evidence that can be presented that further demonstrates that Ms. Kugel was not in a position to observe and did not observe what she says she observed, I think that the likelihood of an acquittal is great. The issue with the Davis brothers, and I find what happened at trial.
Attorney, I can't understand how you can say what you said when, in fact, when you went out there, she said, he called me the night, he called me, meaning Maximilian, and he told me to come to this particular place. I drove the CRX car out there. I met him on the road. She said, we went down this pathway and went into this abandoned building. Was that abandoned building discovered years later by Ortiz and others? Yes.
No, and
hold on, attorney. And then she says, I saw this gentleman in the middle of this building tied to a pole, and he appears to be electrocuted. Did they find a pole where she said that the pole was going to be in this abandoned building out at Grapetree? The answer is yes. She said that there was a generator. Did they find the generator years later out there? The answer is yes. She said it was close to the ocean and to the sea. Was it close to the ocean or the sea? So to say that somehow that there are a lot of inconsistencies in Ms. Kugel's statements, which she admitted, the jurors heard all of that. She was hammered relentlessly on cross-examination, and despite all of that, the jurors heard her testimony, and they heard the testimony on all the evidence that came on from the defense side. And apparently they must have believed her that she was there on June 11 or whatever day it was that evening. And because what she saw or what she told them that was there was discovered 10 years later to be there. How could we close our eyes to all of that, though?
well, I mean, the existence of a building is not evidence of a crime. The presence of
No. Later, you go to the same spot, and the building is still there, or remnants of it might be sort of derelict, but it's still in existence, or remnants of it. And then she named certain things that were in the building, and they're still there. How did she get this knowledge as to where to go, what was in the building, a building that was covered for that was hidden from the road? It took them an hour and a half driving around trying to find this place. I mean, what do we do with that, though? Because the jurors must have considered that.
Well, I understand they must have considered that, the fact that she was familiar with the building. I think what is most concerning to me, and I think Chief Justice Hodge pointed it out, is this Davis brother testimony that never should have been presented. I don't recall in my
did you argue any of that on appeal?
Judge,
it?
Well,
at least I don't recall seeing it anywhere in your appellate papers.
Well, Judge, if we're talking, since I was focusing on the motion for new trial and the evidence that was presented in the motion for new trial. If the argument is that, and I didn't see in the people's argument that that the Davis brothers' evidence provided evidence of that Jose Rivera committed the crime, because the FBI agents admitted, FBI agents' testimony was admitted. I just, I think that's a troubling issue. If
But did you raise that as an issue for a new trial to the trial court below? That's what I'm asking you.
Because if the argument is that the evidence that was brought out by the FBI agents concerning the Davis brothers saying that Rivera admitted to this, that's not substantive evidence, and that's not evidence that should support the denial of the new trial to say that, well, we had that evidence too. It wasn't just Kugel. It was Rivera's admissions through testimony of the FBI agents. I think if we look at whether a new trial, if the rules of procedure and the rules of evidence are followed and the Davis testimony is not admissible, because it's clearly not admissible, then we're left with simply Kugel's testimony. I think that would there likely be an acquittal? I think the answer is yes.
But you've argued throughout that the only evidence against him, eyewitness evidence, was Kugel's. So you really haven't, you accepted that it was only for impeachment purposes, and that the fact that the prosecutor argued that it was in fact corroborating Kugel's testimony. But your time is up and we've gone over, so the matter will be submitted. I thank you both.
Thank you.
Yeah.
Pleasure being with you today.
Very well. I see, Attorney Francisco, you had your hand up, but you've said all you have to say in this case already. Thank you.
Thank you, Justices.
So the matter is submitted.